All right, well, thanks everyone for coming today. I'm Zack with the R Street Institute, a free market think tank in Washington, D.C. We've been working on the patent issue for a little while now, and it rose very suddenly to prominence at the end of last year with the passage of the Innovation Act in the House, and the president putting out his agenda pushing for patent reform with a mention in his State of the Union address, and seeing a bipartisan, bicameral support for the issue come to the Senate. It was surprising to see it just a few weeks ago get killed by Pat Leahy, who decided he would not bring his companion bill to the floor for a vote, or to the Senate Judiciary for a vote. So many have speculated that it'll come back next year if the Republicans take the Senate. So what it might look like under a more Republican reform measure will be certainly considerably different, with Cornyn and Grassley pushing for much stronger fee shifting and other civil litigation reforms. So the Supreme Court is also set to take up, or has also already taken up the software patent issue, and has already heard oral argument and will be announcing a decision soon. So to kick off our discussion on patent reform and what the future in the next few years will look like, I'd like to introduce our panelists today. Adam Mossoff is professor of law at George Mason University. In addition, he's co-director of academic programs and a senior scholar at the Center for Protection of Intellectual Property at GMU, which he also co-founded. Russ Merbath is Chief Policy Counsel at Intellectual Ventures, a firm specializing in acquiring, licensing, and asserting its patents, with a portfolio that ranks in the top 5 largest of U.S. patent holders. He previously worked as a Vice President of Government Affairs at Cricket Communications, and prior to that, a number of communications and law firms working in the telecommunications space. Eli Dourado is a research fellow in the Technology Policy Program at the Mercatus Center at George Mason University. He specializes in internet governance, intellectual property, and the economics of technology. His recent paper with Alex Tabarrok examines public choice and the Bloomington School perspectives on intellectual property, examining synergies and tensions between the two to develop new insights. Charles Duan is Public Knowledge's Director of Patent Reform Charles Duan is the Director of Public Knowledge's Patent Reform Project, where he focuses on intellectual property and innovation policy issues. He was previously a tech policy fellow at the University of Colorado, and prior to that, a practicing patent attorney in Southern California. His recent paper with PK considers 5 areas where patent reform is most needed. So to open up the discussion and consider what's next for patent reform, I'd like to start with Adam Mossoff.
Actually, as the professor, and probably the one that's least associated with the real world, perhaps I could go last.
Okay.
Because by the time you get to me, you really don't need to hear it anymore. So why don't if we could start over there and come this way, I think that'd be kind of
certainly. Charles or Eli, do you have preferences? Who'd like to start?
I can go unless you want to.
Okay, you go ahead.
All right. So first of all, thanks Zach for organizing this. I think the first question in my mind is, this is more or less a privacy conference. Why are we having a patent panel? And I think the reason why, and this ties into kind of what we do at Public Knowledge, is that we recognize a certain value in having an open internet and having available innovation, or having the ability to innovate on that internet. We've seen that is a very valuable thing in many other contexts, and as a result, we strive to protect that in areas of like net neutrality and in areas of fair use, and in many other areas of law. And patents ought to be one of those areas that we are considering that we consider as a potential threat to an open internet. To the extent that they overreach beyond where they're supposed to go. Patents are meant to protect innovation. They're supposed to incentivize the creation of new technologies, and to a large extent they do this. And we see a lot of new inventions. We see a lot of drug discoveries. We see a lot of software inventions that come out of the fact that we have this patent incentive. But at the same time, the number of criticisms about this patent overreaching and being too broad and preventing small companies from developing ideas into useful products for consumers can cause a substantial problem, and those are the problems that threaten the future of the internet. So this is pretty much the area that we're particularly interested in.
Right.
Eli, do you have a few comments to open us up about,
sure.
especially, I know an area you've worked a lot on is the patent quality, software patent,
Right.
business method patent issue.
Sure, I think that it's useful to separate this debate into kind of two issues. I think we would like to get away from, or at least I would, I don't know if Charles would agree, of whether there should be a secondary market in patents. I think that if the patent system is well functioning, that's fine. There can be a secondary market. The problem is that it's not well functioning, and I think there's two reasons. One is the set of actions and tactics that firms are using to enforce their patent rights might exceed what we actually think is reasonable. And you could have a spectrum in what you can do to enforce your rights, all the way from nothing to shooting people on site if you think that they're infringing. And obviously, we don't want shooting people on site, and we think probably you want more protection than nothing. So where do we draw the line? I think that's an important issue. And then the other one is what sort of subject matter should be patentable in the first place? What counts as an invention? Right. So in terms of tactics, what people are doing is they're using shell companies or secret agreements to hide the identity of the party that is actually interested in enforcing the patent. They're transferring standard essential patents to non-practicing entities and then retaining a license, and then telling the NPE, go sue everybody that's using this standard. They are intimidating customers and making demands that are less than the cost of going to trial. So if you send somebody a letter and say, please send us $10,000, and by the way, it'll cost you $20,000 to go to trial, then you get money without any sort of check on whether the patent is valid.
Of course, it's actually more like a couple million.
Yeah, no, it's actually a couple million, but I'm simplifying. But the other thing that I really would like to focus on is patent quality and subject matter. And I think the original sin here is creating a specialized court, the Federal Circuit Court of Appeals, to have exclusive jurisdiction on patent appeals. So if you have a patent trial in federal court anywhere in the country, you can only appeal to one court, and a big chunk of its docket is on patent appeals. So there are all kinds of problems with exclusive jurisdiction. You get specialized judges who come to have the same views as the attorneys that are also specialized in those cases. So they're sort of a reinforcement of the views. You get judges who are screened during the appointment process by patent interests. So if someone's going to be nominated to this specialized court that's going to hear all the patent cases, everybody who has an interest in very strong patent protection exercises a veto over anybody who's not a sure thing in terms of voting for patent-friendly views. And then I think you lose the diversity of views that come with having all of the circuit courts sort of competing to articulate the law. So you lose that. And the result is that over the last 30 years, the law has become much more patent-friendly. There's been a quadrupling of the number of patents issued per year. The Federal Circuit frequently overrules the Supreme Court. The Supreme Court has ruled 3 times that pure software patents are invalid. Yet today we have software patents. And in fact, software patents are over half of all patents being issued now. So if you do the math, right, we've had a quadrupling of patents, and software patents are over half of the patents. So software patents, there's now 2 times as many software patents every year as there were patents issued per year 30 years ago. So it's just a lot of software patents. And the software patents are particularly bad because they're more likely to be litigated than chemical patents, let's say. They're difficult to deal with as a business because there's no good taxonomy of how you define what a software function is, versus like, say, a chemical, you can just write out the molecular formula. Software engineers hate them. I think 80% of software engineers disapprove of software patents, even though you would think that they would be the ones who would benefit from software patents. And then the other issue is that all software is obvious, right? In the normal sense of the word obvious, right? You get someone who is skilled in the art of programming is going to be able to make almost any they're going to be able to make thousands of iterations every day of something that has never been done before. But it's all, so it's novel and it's useful, but it's not. But it is obvious, so it shouldn't be granted patent protection. And then the last thing I'll say on software patents is that there's a multiple marginalization problem. So if I'm producing a device like a smartphone that has thousands of patents, let's just for simplicity, let's say it's using 1,000 software patents, and each of those holders of those patents wants 1% of revenue. What happens? So you get 1,000% of revenue in licensing fees, and the product never gets made. So I think, as an economist, I see this as very much driven by the subject matter. It's just an area where we don't want software to be. Software is not a very good area to have patents in, because it just causes it's very inefficient and causes a lot of hold up and a lot of unnecessary litigation. It doesn't actually improve invention that much.
Now, before I move over to this side of the table, I want to give you guys a little bit more fodder to work with. Eli, you did a great job talking.
Well, that's a lot.
Eli, you did a great job talking about patent quality and software patents. But first, Charles, I was hoping you would explain to the audience just a little bit more about some of the civil litigation reforms that had been discussed in Congress. What's good about them and what's contentious about them before I move over and give you guys a chance to respond.
Yeah, so basically, what happened was that we had a number of bills going through Congress. There was one main one in the House that passed with a very high margin. I don't remember the exact numbers, and it moved into the Senate, where it was moving along until it seemed like some political forces killed it. The overall ideas behind those two bills were to basically level out the playing field. The concern among lawmakers was that it was very easy to bring a case. It was very easy to bring both a legitimate case and an illegitimate case, and all of these cases are very hard to defend. So the idea is, if we can come up with some way of distinguishing between the legitimate cases and the illegitimate cases, and making it much more difficult for those illegitimate cases to go forward, then we would be dealing with a lot of the abuse within the system. So there are a couple of places in the process that they were looking at. First of all, just starting from the very beginning of a lawsuit, there's kind of this loophole about when you filed a lawsuit. You would think that normally when you file a lawsuit, you have to kind of explain, what's the problem, what's the problem, what do you think the other person did wrong, so that they understand what they're fighting against. This is a concept called notice pleading. This is enshrined by Supreme Court decisions, Iqbal and Twombly, and this was fine for every other area of the law except in patents, where there was a loophole, which basically said that if you write down the patent number and the name of the patent owner, that was more or less enough to get you into court. So basically, if I had a patent and I saw that you were doing something like using a computer, I could go to you and say, hey, I could sue you and say, hey, I think you're infringing my patent. Here's the patent number, and you have to figure out, what am I doing that infringes this patent? So one of the fixes was to say, okay, we need you to actually specify, what's going on in this case. That was called basically the heightened pleadings, or fixing the pleading standards. The second one dealt with discovery reforms. So this is the phase of a lawsuit in which we are engaged in a lawsuit. You and I are exchanging documents about what was going on. And one of the things that I could do was I could say, I want you to disclose to me, thousands of pages of documents, and you're going to have to review all of those thousands of pages of documents. You're going to have to hire lawyers to go through them. You're going to have to figure it all out. It's going to cost you a lot of money. And in a lot of cases, that's a legitimate thing to do, because I need information in order to proceed with my case, and that's fair. But in a lot of cases, I could just say, give me a lot of paper, because I know it's going to cost you a lot of money. And the sense is that that's not a fair way to play the game. So, so the second of these reforms was to try to limit that problem by, by shifting the costs over to the party who's requesting the discovery, and also, adjusting the timing so that I wasn't able to go off and ask you for all of these documents at any time in the case. And the third one was basically fee shifting, and the idea behind that was, if I bring a patent lawsuit, I can find a contingency fee law firm, and they'll go off and handle all these things for me. If I win, I get a lot of money. If I lose, I walk away, with nothing. So, my positions are 0 or lots of money. On the other side, if I'm defending against a lawsuit, if I win, if I lose, then I have to pay out the damages, and that can be very high. And if I win the case, if I prove the patent's invalid, then I also have to pay a lot of lawyer fees. So basically, it's lose-lose on one side and essentially win-win on the other. And it was thought that this sort of system does not incentivize the right kinds of lawsuits being brought, because I could bring a lawsuit on a totally illegitimate patent, knowing the fact that on the other side the party is thinking, well, I'm either going to pay money or pay money. I might as well settle with them. And so the idea was, if we put some of that lose-lose risk on both sides, then both sides would start thinking a little more carefully about making sure that the case they were bringing is one that makes sense and is one that would actually stand up. So these were basically the litigation reforms that were talked about.
Now for the record, I mean, fee shifting and what standard should be set for that was one of the most contentious things.
The idea would not be that you would anytime somebody lost a case, they would have to shift the fees. The courts would basically be looking for a case that's particularly, I think the words were unreasonable or.
Well, what standard would you advocate for?
Yeah, I think I remember that I liked the standard that they had, and I just don't remember the exact words that they were using.
Well, the standard was it was
I think it was unreasonably reasonably justified.
The standard was fees shall be shifted, so it was a mandatory fee shifting fee unless you can prove that the lawsuit was not brought without reasonable justification.
Yeah, it was reasonable justification.
But that means that means the fees shifted as a default rule, but for additional explanation.
They were talking about both situations. There was
but the Innovation Act had mandatory fee shifting, and that was one of the sticking points because the but-for language wanted to be taken out by Corner. And they wanted absolute mandatory fee shifting across the board.
I believe that the compromise they supposedly came to before it got pulled had a weaker standard for that. Is that right?
Yeah.
Well, there was a lot of back and forth with the different language, but the language in the bill, as passed by the House at least, was a mandatory fee shifting regime.
So just kind of unpacking this, it's a pretty complicated issue. There are two issues when it comes to deciding, when the loser of the case has to pay the fees. The first issue is just, what's the level of unreasonableness of the case? You could say fees are shifted in all cases. That is not what they were talking about. You could say that fees are shifted only in truly exceptional cases. That's actually the law right now, and they wanted something a little stronger than that because that was almost impossible to reach. So what they settled on for that standard was this reasonably justified. As long as your case was reasonably justified, then you had a good reason for bringing your case. But if your case wasn't reasonably justified, then and you lose the case, then it makes sense for them to say, well, you knew what was going on when you were going in, so you ought to bear the risk for that. So that's the first issue.
I should probably move over here pretty soon. So we'll come back to unpacking the details a little more. But Russ, would you like to be the first to respond since Adam wanted to be last?
Sure. No, I just have one comment really. And first, thank you, Zack and R Street for inviting us to be here today. I think some of the problem that people are complaining about, or some of the issue that people are complaining about, goes to a point that Eli made, and that is about the secondary market. And I think that the problem we're facing is that the secondary market is still not very well developed. And if it were far better developed, something that Intellectual Ventures is engaged in trying to achieve, that we would have there would be more certainty, more understanding, and greater clarity of what we're dealing with here. I think the reason we wind up in litigation so often, and I don't mean Intellectual Ventures, I mean why litigation seems to be fairly frequent in the patent space, is because it's hard to determine the value of a patent, and you wind up having to have an arbiter who will sit and try to understand this and come to some judgment. So I think part of what's being complained about really is driven by the fact of the poor development to this point of the secondary market.
Let me just follow up with you. What would you see as being a better way to develop this market? Is that through, more kind of systematic forms of licensing that people can expect, or?
Well, it's interesting because it does come down to a question of respect for intellectual property, and there's been a weakening of respect for intellectual property. We have attempted to perform a market clearing function at Intellectual Ventures where we're buying a lot of patents, and we will bundle patents and offer them to companies for licensing so that they have effectively a one-stop shop for the intellectual property rights that they need to bridge, say, an invention gap between the IP that they might hold and what the product actually is covered by.
And for those who are interested in the concept of the invention gap, the person who coined that term, Greg Gorder, and has developed their IV, actually published an article on it in the George Mason Law Review that just came out last month. And in fact, it's a great issue. It also has an article by Commissioner Joshua Wright of the Federal Trade Commission on applying incomplete contract theory from economics to FRAND agreements with respect to standard essential organizations and standard essential patents and other types of issues.
Can you just briefly explain what FRAND and RAND agreements are?
Sure. So FRAND is just when you commit a patent to something that was mentioned earlier, to a standard setting organization. It's part of the contract. It's a private contract among different people to agree upon a standard, and people with patents that cover those standards agree that they'll license the patents that cover those standards on what are referred to as fair, reasonable, and non-discriminatory terms. And it goes by the acronym FRAND. And it's been a point of much litigation in recent years, although interestingly enough there was no significant litigation over FRAND agreements for approximately the past 40 or 50 years. It's only been in the past couple of years that there have been 3, 4, 5, 6 cases that have arisen, and there's some question about how these issues are applied. They're very fact specific. These are contract disputes at root, not patent disputes. That was just kind of an aside because I wanted to tie into his comment about the invention gap. But Zach, thank you for inviting me to speak here on Mossoff, and for those who don't remember, is Zach's introduction. And since this panel is organized by R Street and it's an internet conference associated with people who I think who have general libertarian leanings with respect to the internet, the title of the conference is keep the internet free.
They would probably say civil libertarians.
Civil libertarians of sort. I do think it bears noting that I'm gonna key my remarks, I think, to libertarians and to people who I think would appreciate it with what R Street does. So the internet represents. I teach internet law. It's a great course. It changes every year. It's one of the things I love about teaching it. And the theme of my course really, how do you teach a class that changes every year? And so the theme really is, how does the law respond to vast, massive technological, social, and economic changes wrought by changes in the way people interact in society? And the internet has certainly brought that about. But we often forget that there actually was a similar revolution that occurred before the digital revolution. It was the Industrial Revolution of the 19th century, and it raised the exact same questions. In fact, Larry Lessig of internet law fame actually has a very famous exchange with Judge Frank Easterbrook on whether internet law is an appropriate subject or not. Judge Easterbrook says it's not. It's like this area they used to call the law of the horse back in the 19th century, where there were whole treatises on horse law, and there was insurance sections and tort sections and property sections and whatnot. Now we think of that as crazy because there's property law and intellectual property law and things of that sort. But the important point about the Industrial Revolution and the revolution that wrought in the 19th century is it brought with it the same type of reactions. And libertarians and conservatives at R Street often complain about the reactions to the Industrial Revolution. In fact, they have very similar complaints about the fact that excessive rhetoric, like robber barons, were used at the end of the 19th century. There were bad facts and statistics being deployed in courts and in Congress with respect to legislation that was being proposed in response to the Industrial Revolution. My colleague at George Mason, David Bernstein, has written a very interesting book called on the Lochner decision and the actual underlying facts that underlie Lochner and what was going on in that case, which has been buried under a lot of, I think, historical myth. And I don't think, unsurprisingly, today you see the exact same concerns, right? So excessive, inappropriate rhetoric. I think the par excellence example of that is patent troll. Right, this is a term that I think everyone uses now, just like everyone used to use or once used robber baron, and yet people have no clear sense necessarily what this means. They think of some nefarious actor in the marketplace, and certainly there are bad actors, but there's always bad actors in a legal system. But the term has been applied against individual inventors, it's been applied against universities, it's been applied against major manufacturers. General Electric, Richard Rainey of General Electric loves to talk about how part of General Electric's business model is to acquire in the secondary market patents so that they can assert them. He says, we're a patent troll. If General Electric is a patent troll, and IBM has also been accused of being a patent troll, everyone's a patent troll at the end of the day. The term has lost any meaning, and yet it's driving legislation on the Hill, it's driving court decisions, it's driving regulations, and I think we need to be very wary of that. What underlies the rhetoric also is a lot of really bad statistics. So sometimes you often hear, for instance, a statistic that public knowledge likes to throw around is patent trolls caused $29 billion in damage to the economy.
I have rarely used that number.
Okay. Well, your former colleague, Julie Samuels, invoked that in testimony that I was sitting with their hearing at the Senate. The very study that the General Accountability Office of the U.S. Congress, when it was asked to assess all of these studies, identified these studies as, quote, non-random and non-generalizable, which means that they came from highly selective, biased data sets, very small data sets that were, in fact, you could not draw generalizations from them. In fact, that's a non-random and non-generalizable. That's statistic speak for what the rest of us would refer to as a junk study, right? The whole point of having a statistical study is that it be based upon random data so that you can generalize it to the larger population. And so what I'm really concerned about here is that we have a patent policy discourse today that has become largely driven by what I think is improper rhetoric and largely exists in a fact-free zone, where you have claims being made about certain things and about behaviors with actually, we don't really have any understanding of what's actually going on in the marketplace, what's going on in courts, what's going on in how the patent system functions. And so just to tie it back a little bit, just very quickly to some of the earlier remarks, for instance, Eli's talking about software patents. Well, what a lot of people don't know is actually that is not a term of art in patent law. There's no category called software patents at the Patent Office. The Patent Office does not issue anything that it calls a software patent. Nothing. What it issues is patents that cover electrical engineering inventions. It also covers patents covering coffee machines. As you know, if you operate a Keurig machine, you have software in your patent. In that, you have software in your refrigerators. A friend of mine just had his software burn out on his refrigerator and had to have the whole motherboard replaced because it was a badly designed motherboard. There's software in your automobiles, and to the extent that there's patents that cover those particular inventions and they have a particular claim in them that covers software, guess what? They fall into this broader category of software patents, this very loose rhetoric that we use. And this is why, for instance, you get this claim that 50% of all patents issued at the Patent Office are software patents. When everyone in their head is thinking, oh, that means computer programs like Word for Windows or an operating system. That's not true. That's not true at all. And so I think what we really have to do is be more precise about the facts underlying our claims, and we really need to find out what's going on in the innovation economy and with respect to patent innovation, how it's being deployed both as a commercial asset and how it's being used in the courts by both plaintiffs and defendants, and to the extent to which we then are pushing for radical reforms to our patent system.
So I'm going to give you guys the opportunity to respond. I want to hold off on the software patent question for a moment and just deal with the idea of are patent trolls a problem? We talked, I believe, Eli, you mentioned the term of NPE, which is non-practicing entity, and I think we should be careful in separating, bad actors versus NPEs as a kind of useful secondary market function. First of all, do you agree with that statement? And how would you assess the problem of patent assertion by bad actors, and what are the economic costs of it?
I think I tried to get at this when I started my remarks. what I think we want to focus on is what tactics are okay and which tactics are not okay for enforcing patent rights. So I think that the tactics that often get are being implicitly referred to when people talk about patent trolls, that those tactics are the problem, right? It's you know, hiding your identity. It's sending demand letters to customers in order to extort a settlement from the manufacturer of the product. Those kinds of actions are what is driving the debate. It doesn't. Whether we call them patent trolls or not is not really what's important. Should that be allowed in enforcement?
Can I just take one issue with that? I don't know that that's what's driving the debate. I think that's what's animating the debate. I think what's driving the debate is actually big tech not wanting to be responsible for paying for the IP that they're using.
No, but that's just...
And the cover for that, sorry, just one more thing.
Sure.
The cover for that, or the animating factor, are mom and pop shops and retailers and restaurants that are being hit with demand letters that, as far as we can tell, and we've not seen, to Adam's point, any really good statistics on this, but as far as we can tell, those are specious demands. These are sent out by parties that hold a few patents and don't have any intention of actually following up with a lawsuit, because they're really trying to just get a cheap settlement out of somebody by scaring them. So I think if we were to deal with those issues, I do agree with you that there are a certain set of behaviors that really ought to be dealt with. So
okay.
we're not totally opposite here.
Okay,
there are a set of behaviors that ought to be dealt with, and the demand letter issue and a customer stay issue are things that really could be focused on, I think, very profitably by Congress and regulators to deal with the behavior that is animating the debate. But I think what's really funding the debate is big tech.
Okay, but I think that you're begging the question a little bit, right? Because you're saying big tech doesn't want to pay for the intellectual property that is being produced by inventors. But when part of the debate is actually what should be defined as property, right? What should count as a patentable invention? And I think people who are skeptical would say, you know, a lot of inventions hold to refresh on your iPhone or on your Android device. That is patented, right? Is that really an invention? Fortunately, Twitter owns that patent and they're not weaponizing it. But
I think that's a good point, and that ties in with core policy debates that have existed in this country since the patent system was the copyright system was begun in 1790. I think part of the issue is maybe to be a bit more precise. What Russ is getting at is it's not. And to build upon your point about how your earlier reference to public choice theories, that I don't think you're recognizing that public choice applies on both sides of the debates. And what you have here are big tech, and we have to be careful about how we use the phrase big tech, because there are some big tech companies that are very, very, very much like patents, patents on software. IBM, Microsoft, Apple. These are companies that you won't find them out there saying we shouldn't have patents on software. Why? Because they built business models that require them to develop software in which they invest tens of billions of dollars in creating what they would call enterprise software, operating systems, word processors, not apps on your phones. And before they see a cent on sales, and they have to recoup their investments on that. And so you see very similar R&D dynamics in the high-tech industry that you see in the pharmaceutical industry that people actually say patents should be legitimate for. On the other side of the high-tech divide, though, Google, Twitter, Facebook, what you have are companies that have built business models not around patents, but around other commercial assets. And they see patents as obstructing their deployment of their business models. And so what I witness happening in DC today is a contest between different types of business models in the innovation industries, where one type of business model that doesn't rely upon patents is trying to weaken patents because they are because they have a business model that depends upon the more free use of those types of assets that may be covered by patents themselves. And I just think we need to be sensitive to that, to that reality, because that's part of public choice, right? I mean, that applies just as much as the public choice argument on the patent side.
Well, let me just interject here and mention that we were going to have an additional panelist from Microsoft, and it's worth mentioning that they were supportive of the Innovation Act and the final Senate package, barring some things that they were concerned about.
Well, no, I'm touching on the software patent issue. So,
okay.
As Eli and others mentioned, that Supreme Court's going to be deciding whether software is patentable or not.
Again, for the fourth time.
Yeah. Well, no, I disagree with you. The Supreme Court has never held as such that software is not patentable.
They've said pure algorithms are not patentable.
Well, that's an interesting thing. What is a pure algorithm?
Right.
A software program isn't necessarily a pure algorithm. The argument that a software is math proves too much, because at the end of the day, you can reduce every invention down to math. In fact, physicists love to say math is the language of the universe. You can ultimately describe everything as a mathematical algorithm if you'd like to, including any method or process, including industrial processes. So, the engines are built upon the laws of thermodynamics, which are a mathematical formula. So So you have to be careful about the claims about that, well, software is just an algorithm or just math, because at the end of the day, a computer program is like a Word for Windows, or what you're using right now to take notes on, or to send emails, or to check your email, or to post to Twitter. That's not the same thing as saying 2 + 2 = 4. That's actually a type of machine. It's a digital machine, in the same way that industrial machines came into existence in the 19th century. Typewriters were as radical to handwriting as email is to typewriting, or as a word processing is to a typewriter. And that's exactly what our patent system is designed to capture, that new innovation, the new values that are created for deployment in the marketplace.
I don't think we're going to resolve this, but I just want to say that I think software is math.
Okay, I kind of want to jump in here because it seems like we're really getting in the weeds, and we're also kind of seeing this as, okay, so they're like companies on one side, companies on the other side, and this is like fight between companies. I'm a public interest organization representative, so there is actually that side of things. So where does that fit in? The way I think it fits in is this. You imagine back 50 years ago, and if you wanted to watch video, what did you do? You turn on the television. There were maybe like 10 channels on there. You had to pick from one of those, right? People were content consumers, and there was a very small number of content creators. These days, if you want to watch video, where do you go? You go to the internet. You go on YouTube, you find content made by tons and tons of people all over the place, all sorts of diversity, all sorts of really great ideas, coming from small creators, individuals who have, they have their own little idea. It's easy for them to do this. And what we saw in the internet context was that you could have laws that really got in the way of this productivity. You could have copyright laws that made it really hard to make remixes. You could have, DMCA takedowns that would make it very difficult for people to put out content without being worried about it. And what we have found is that, to the extent that we can promote this sort of grassroots spontaneous creativity, that has really driven a lot of interesting, creative, valuable innovation. And when it comes to patents, I think we can kind of see the same trend, right? Right now, I think the vision is that all of the big inventions come from like big companies. It's like huge firms like pharmaceutical companies or manufacturing companies that make everything, and we're just consumers and we just buy things. But now that it's so easy to program a computer, when 3D printing becomes a really big thing, when it becomes really easy to manufacture something, when it becomes really easy just to find an off-site manufacturer who will help you make something that you wouldn't be able to have done 50 years ago, when that level of innovative capacity is available to all consumers, we need to make sure that the law is catching up with that. We need to make sure that we don't have laws that are basically protecting a model of business that assumes that only large companies are the ones doing this. We need to make sure that everybody can do this. So if I come up with a piece of software right now that I can make very easily, and I have to be worried about somebody coming after me with this very broad patent that I have no idea about, that creates a very different world than if it's just I can come up with this sort of interesting software and share it with people. And I think that you can say, well, yeah, you should be a large enough company so you can pay licenses and deal with all the legal stuff. And that is a world we could have, but I'm not sure it's a world I like. I like the world in which everybody can make things, in which everybody can come up with things. I do like the world also that has patents and that has big companies that make lots of useful products for us, but that doesn't mean that I only want that. I want a balance between those two things. And that means I think we need a balance in what we have as patent law. Patent law right now is geared toward this idea of ensuring that each company is kind of working on their own thing and is working on something different, so that ultimately we have a smaller number of firms that are capable of handling all of the legal requirements that go behind these things. But I think that today, now that we have the internet, now that we have all of this really cool technology, I think things are really different, and the law needs to catch up there.
I would I agree with you all the way to your conclusion, right? Because in a sense, to me, the patent system exemplifies something that I think libertarians will usually embrace, which is the genius of a property rights system, which permits anyone to do whatever they want with the asset that they have in question. It doesn't constrain them. You can become a landlord and rent out your property. You can build a house. You can sell the land or sell the air rights or build a skyscraper or build a factory or do whatever you want, because it's a property right. And all that property right does is says you have the exclusive right to use this thing in the world and in the marketplace however you choose, including giving it away for free if you want, because that's what some property right owners do. And in fact, the genius of our patent system is not that it's for big companies, it's that it serves small individual inventors. In fact, what a lot of people aren't aware of is that 30% of applications at the Patent Office are still small companies, small entities, and independent inventors. And the big tech companies started as garages, and they started as graduate students. In fact, something that Google doesn't like to talk about very often is that Sergey Brin and Larry Page got a patent on their algorithm in 1998 that became the Google search algorithm. And why did they get a patent on that? Because venture capitalists repeatedly tell you that they rely upon patents to make their venture capital investment decisions for small companies. Bill Gates was one of the very first people in 1977 writing an open letter to what was then known as the hobbyist community, which we later call the hacker community, saying we have to embrace intellectual property if we are going to become a vibrant industry with lots of different business models and lots of different companies. And so it's exactly the patent system which has made it possible for that small individual inventors and which are the drivers of innovation, and the small companies which challenge the big established companies and their existing business models, knocking them out of place with that wonderful creative destruction that Joseph Schumpeter heralded, and replacing them with, and that's made possible by having property rights and innovation, where you have the ability to choose what your business model is, and the property right is what secures you against the larger company and the established business model by saying, I have a property right. And that's why venture capitalists love it. And that's why it's the basis of what become very successful companies, and becomes the basis of the successful companies that knock those successful companies out of the way.
Yeah, and I agree with you to the extent that you're saying, there are a lot of small inventors that rely on patents, and that's fine. But it's not all the small inventors. And in fact, we take a look at things like the open source community, right? They're innovating left and right, and they don't rely on patents to
right. You know what they rely upon? Trademark. I mean, so this is the tendency to think all IP is patents or all IP is copyrights. And what people don't realize is that no, there's an IP system, and like all the systems, and people can choose the legal protection based upon the business model that they want to deploy.
Right.
So the point about open source is great, because that's exactly it. Open source is not really a business model, right? And insofar as you're giving away stuff for free, so how do you then capitalize?
Right.
Well, you have trademark protection. If you don't think Red Hat doesn't have trademark protection on Red Hat, you're kidding yourself.
Well, yeah,
in fact, they actually have it as a requirement that you remove all references to Red Hat in their general licensing.
Mm-hmm. Sure, and that's fine. But I'm not talking about business models. I'm talking about innovation models. And the fact is that we have people who are incentivized to create things, not based on the patent incentive. And we have people who are actually dissuaded from innovating because of the patent incentive, especially when those patents start becoming so overbroad that they are creeping into all of the things that we're doing in our daily lives. And that's, that's really where the concern comes from. It's not that, we don't want to give people the option to use patents. It is that to the extent that, patents are making it harder for other people to actually innovate, that starts becoming a real problem. That especially becomes a real problem when it comes to these really overbroad patents that I think we hear about a lot in the news. When people say that, these guys have got a patent on rounded rectangles or whatever. A lot of those reports are a little bit complicated in terms of their accuracy, but the idea is basically there. The fact that there are patents out there that are broadly asserted, that are hard to read, that inventors can't figure out whether or not they can move forward with what they're doing in view of these things. I think that is a pretty substantial chilling effect that we ought to be taking into consideration.
I want to speak to the property issue because libertarians do support property, right? But what's the interest? What I keep coming back to, and the distinction between intellectual property and non-intellectual property, is that non-intellectual property law developed over centuries through like decentralized common law rulings, and intellectual property law is devised by Congress and now a specialized court that hears all appeals. So the public choice problems, the problems of lobbying and influencing policy are much more severe in IP, and you have to. I mean, anybody who accepts public choice would probably have to say there's got to be at least some sort of problem with that, right?
Well, thanks, Eli. Because for those who know, I teach property every year, and this is something I did an extensive blog post called the common law property myth in the libertarian critique of intellectual property. It is entirely false that property rights and land developed just at courts over the span of thousands of years. In fact, what every property law teaches their law students every year is that actually the Anglo-American property system, the British-American property system, starts with a statute called the Statute of Quae Emptoris of 1290. And that wasn't the first statute. That wasn't the first and last statute. There were many statutes that followed that. The statute of uses, the rule against perpetuities, the statute of wills and trusts. What you have is a dynamic between courts and parliament, and then courts and state legislatures over the span of hundreds of years, where property rights are defined and secured to the creators of value. And as value is defined, it becomes more expanded and more abstract in some contexts. So you have corporate value, creation of corporations in the 19th century, which is just a new phenomenon, purely corporate. So libertarians love corporations and it's entirely statutory, yes, because a new type of value was created in an organization of people and of the means of production. You had the same type of recognition of the value and importance of intellectual property. And this was the justification for it. In fact, there was a sound justification for it by the same people who justified property rights and land in the 18th and 19th centuries. And so it's not true, again, that property rights and land developed over the course of the century, and then you had like legislatures come in in response to people who were lobbying the legislature. It's not true on the land side, and by the way, it's not true on the IP side. I mean, we were just talking the Supreme Court decides these cases. There's actually, what I teach when I teach patent law every year too, is I don't teach statutes, I teach court decisions. The majority of patent law is actually court-made law, made by the Supreme Court, or the lower courts over the time, and you were just complaining about how we have this special federal court because what was Eli's problem with it is that it's making patent law and they're too cozy with the patent bar. So I mean I'm
saying that public choice issues apply to that court.
So I mean
very strong.
But that's a concession that patent law is judge-made law and always has been judge-made law. Majority of it is. What you have is very broadly framed statutes that the judges then develop and apply. Like the Supreme Court deciding whether software is patentable. That's not Congress deciding that. That's a Supreme Court as a judge-made issue.
Well, Congress very well could decide to abolish software patents. And in any case, Congress created the Federal Circuit at the behest of the patent bar.
My hope is that we don't change the system responsible for innovation in this country on a bunch of coulda, woulda, and shouldas, but that we actually base our decisions on facts, real statistics, real knowledge. What is the extent of people being shut down? Not claims, unsubstantiated claims of, well, there's a substantial burden on innovators. I would like to know how much burden. Where is the burden occurring? How much is patent innovation contributing to the economy? How is it being deployed? These are important questions, and these are the unanswered questions that we have today.
And at the same time, I think we want to make sure that we don't defend the system without accounting for the changes that have happened. You know, I know that, Adam, you like to compare the sewing machine wars to what we have right now. Yeah. But you know, I think the world has changed. I think that innovation has been democratized in a way we've really never seen before. And you know, in the same way that we have problems with copyright not adapting well to the digital era, in the same way that we have problems with privacy not adapting well to the digital era, in the same way that we have problems with a lot of laws just not adapting well to the digital era, I think we really do need to consider, you know, what has changed? What has changed is the fact that, you know, people are able to innovate in ways they couldn't before. And how do we adapt the laws around innovation to ensure that they can do that? And that, I think, is fundamentally why patent reform is a public problem and not just an issue between two companies. Because of the fact that, you know, everyone here has, you know, used a computer in a way that's probably innovative and probably, you know, covered by some sort of patent. This is, you know, we are in a different world, and I think it's worth rethinking, you know, how we go about incentivizing innovation, incentivizing creation of new ideas in this different world.
And I would just add to that, because I think you're right in a lot of ways. It's important to incentivize innovation without disincentivizing invention. And invention rights are what we're talking about here. And without the protection of invention rights, to Adam's point earlier, or repeating it, investment often doesn't happen, at least not at the level that really promotes further invention. Innovation, changes to things that have already been done, that's one thing. But real invention, I think, does need strong intellectual property protection.
Now, do we have another minute or two where we can go over? Yeah.
It's not fun
No.
change.
Okay.
That's okay.
All right. Well, thank you, everyone.
Thank you for listening. Appreciate it.